Myself, Dr. Anjali Bansal. I am Assistant Professor, Punjab University, Chandigarh. The topic of my presentation is Equality to Reservations. Reservations. The correct term used for reservation in the Indian Constitution is representation. It is not given to anyone in his individual capacity. It is given to individual as a representative of the underprivileged community. Reservation is a democratic principle to provide representation to the castes remained unrepresented in the governance of the country. Those responsible for implementing the policy of reservation must undoubtedly understand that reservation is neither a policy matter nor a political gimmick or a matter of charity. It is a constitutional obligation. The purpose for reservation is that there should be an inclusive social order. Inclusive social order is a system of governance through a kind of political arrangement in which members of different sections of society have opportunity to participate on equal footing. Such a social order serves two purposes. First, participatory social order is conducive to peaceful and sustainable development of society. The system of governance, which includes certain factions of the society, creates tension and is inimical to development. Secondly, it augments pool of human right development. Then the legitimacy of policy of reservation. Legitimacy of policy of reservation can be studied at two levels. First, conceptual level, and the second is practical level. At conceptual level, the creation of political document, that is constitution, with the consent of all by promoting fraternity and solidarity, which is a condition precedent. In preamble, Dr. Ambedkar, as a political scientist, has made political arrangement to cut across those barriers. The preamble to the Indian Constitution provides that there should be equality of status and opportunity. Moreover, every effort should be made to promote fraternity among all the people, assuring dignity of the individual. Then, legitimacy at conceptual level. The preamble of the Constitution provides equality of status and opportunity and promotion of fraternity. Then, legitimacy at functional level. At functional level, the notion of fraternity is explored through strategy of reservation. Though the concept of reservation and equality are poles apart, but this principle of reservation has been introduced in the Constitution along with the principle of equality. Types of reservation. Reservation could be of two types: vertical reservation and horizontal reservation. Vertical reservation, where a vertical reservation is made in favor of a backward class under Article 16, Clause 4. The candidates belonging to such backward class may compete for non-reserved posts, and if they are appointed to the non-reserved posts on their own merit, their numbers will not be counted against the quota reserved for the respective backward class. If the number of SC candidates who, by their own merit, get selected to the open competition vacancies equals or even exceeds the percentage of posts reserved for SC candidates, it cannot be said the reservation quota for SCs has been filled. The entire reservation quota will be intact and available in addition to those selected under open competition category. For example, suppose there are total 200 seats, and out of 200 seats 170 belong to general category and 30 seats belong to reserved category. Even out of 170 seats in general category, 40 SC/ST candidates got selected on merit basis in this category only. Selection of these 40 SC/ST candidates in general category will not affect the seats which are specifically reserved for them. Second, horizontal reservation, where a special reservation for women is provided within the social reservation for scheduled castes. The proper procedure is first to fill up the quota for scheduled castes in order of merit and then find out the number of candidates among them who belong to the special reservation group of scheduled castes, that is women. If the number of women in such list is equal to or more than the number of special reservation quota, then there is no need for further selection towards the special reservation quota. Only if there is any shortfall, the requisite number of scheduled caste women shall have to be taken by deleting the corresponding number of candidates from the bottom of the list relating to the scheduled caste. For example, if the 19 posts are reserved for scheduled caste, out of which quota for women is 4, 19 scheduled caste candidates shall have to be first listed in accordance with the merit from out of the successful eligible candidates. If such list of 19 candidates contains 4 SC women candidates, then there is no need to disturb the list by including any further SC women candidate. On the other hand, if the list of 19 SC candidates contains only 2 women candidates, then the next 2 SC women candidates have to be selected in accordance with the merit, and corresponding number of candidates from the bottom of such list shall have to be deleted so as to ensure that the final 19 selected SC candidates contain 4 women SC candidates. Then the juxtaposition of reservation and equality. Equality is the prime principle and starting point of all other liberties. Our constitution contains code of equality, that is Article 14, 15 and 16. Article 14 is a generic term and can be expounded infinitely. Article 15 and Article 16 are restatement of Article 14 in Indian context. Article 15 is the most central to it. Article 15. Article 15 provides equality by clauses 1 and 2, but the same has been negated by subsequent clauses which permits making of special provisions in favor of some particular classes. Clause 1 of Article 15 directs the state not to discriminate against a citizen on grounds only of religion, race, caste, sex or place of birth or any of them. The prominence of the word only lies in the fact that Article 15 will come into play only in those cases where discrimination has been done solely on the ground of religion, race, caste, sex or place of birth. It signifies that other qualifications being equal, religion, race, caste, sex or place of birth cannot be a ground of preference. Clause 2 prohibits citizens as well as the state from making such discrimination with regard to access to shops, hotels, etc. and all places of public entertainment, of public resort, wells, tanks, road, etc. Clause 1 of Article 15 prohibits discrimination in any matter which is exclusively within the control of the state, whereas Clause 2 prohibits both the state and the private individual whosoever is in the control of above mentioned places. Clause 2 is a particular application of the general principle against discrimination embodied in Clause 1. Clause 3 empowers the state to make special provisions for the protection of women and children. For example, Article 42 of the Constitution enjoins the state to make special provision for securing just and humane conditions of work and for maternity relief. A law made by the Parliament to implement this directive, like the Maternity Benefits Act 1961 and the Factories Act 1948 would fall within purview of Article 15, Clause 3. Clause 4, which was added by the Constitution First Amendment Act 1951, enables the state to make special provisions for the protection of the interests of the backward class of citizens. This amendment was made as a sequel to the decisions of the Supreme Court in State of Madras versus Champakam Dorai Rajan. In this case, the Madras government issued a communal GO providing for reservation of seats in the state medical and engineering colleges for different communities in proportion of students of each community. The Supreme Court held the order to be violative of Article 15, Clause 1 as seats were reserved on ground of religion, race and caste. In order to nullify the effect of this judgment, Clause 4 was added to Article 15. Article 16. Article 16, Clause 1 contains another facet of equality. It secures equality of opportunity in matters relating to public employment to every citizen, but it does not prevent the state from prescribing the requisite qualifications and the selection procedure for recruitment or appointment. Such qualifications may include mental excellence, physical fitness, sense of discipline and moral integrity, etc. These should not be arbitrary. It must be based on reasonable ground, having nexus with the efficient performance of the duties and obligations attached to that particular office or post. Clause 2 of Article 16 further strengthens the guarantee contained in Clause 1. Clause 2 prohibits the state from making discrimination against any citizen in respect of any employment or office under the state only on grounds of religion, race, caste, sex, descent and place of birth, residence or any of them. There would be no contravention of this clause where discrimination is based on grounds other than those mentioned in Clause 2 or partly on ground mentioned in this clause and partly on some other considerations. Clause 3 empowers the Parliament to make any law prescribing any requirement as to residence within that state or union territory. Clause 4 permits the state to make provision for the reservation of appointments or posts in favor of any backward class of citizens who are not adequately represented in the services under the state. It is only an enabling provision which has been enacted to secure egalitarian equality. Clause 5 provides that a law may prescribe that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Reconciliation between two conflicting concepts of equality and reservation. In M.R. Balaji versus State of Mysore and T. Devadasan versus Union of India, the Supreme Court held that the provision of reservation is in the nature of an exception which completely excludes the rest of the society, is clearly outside the scope of Article 415, Clause 4. A proviso or an exception cannot be so interpreted as to nullify or destroy the main provision. Then attempt has been made to deviate from the narrow view given in T. Devadasan case, and this attempt has been made by Justice Subba Rao in T. Devadasan's case, who has given a dissenting judgment. In this case, Justice Subba Rao held that Article 16, Clause 4 of the Constitution of India has not really carved out an exception, but has reserved a power untrammeled by the other provisions of the article. In state of Kerala versus N.M. Thomas, backwardness of the weaker sections of the society becomes one of the form of classification. Preferential representation for the backward classes in services with due regard to administrative efficiency is permissible object, and backward classes are a rational classification recognized by our constitution. In TMA Pai Foundation versus State of Karnataka, the conversion of formal equality into fact through education has been stressed and emphasized by the court. The state cannot insist on private educational institutions which receive no aid from the state to implement state's policy on reservation for granting admission on lesser percentage of marks, that is, on any criteria except merit. The Constitution 93rd Amendment Act 2005 has been passed. This amendment has added Clause 5 to Article 15. This clause enables the state to make special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes insofar as such special provisions relate to their admission to educational institutions, including the private educational institutions, whether aided or unaided by the state other than the minority educational institutions. Last of all, Ashok Kumar Thakur versus Union of India, the Supreme Court further held that Clause 4 of Article 15 is neither an exception nor a proviso to Clause 1 of Article 15. Clause 4 has been considered to be an instance of classification inherent in Clause 1 and an emphatic restatement of the principles implicit in Clause 1 of Article 15. Then, different horizons of the concept of reservation. In M.R. Balaji versus State of Mysore, the Mysore government issued an order reserving seats in the medical and engineering colleges in the states in the following manner, that is, backward class 28%, more backward classes 20%, and the scheduled castes and scheduled tribes 18%. Thus, only 32% seats were left for general merit pool and 68% of the available seats in the colleges were reserved seats. The Supreme Court held that the order is inconsistent with Article 15, Clause 4 and laid down the following propositions in this case. First, caste should not be made a sole basis to determine backwardness, and so the classification of socially backward citizens on the basis of their caste alone is not permissible under Article 15, Clause 4. Secondly, a special provision should be less than 50% of total vacancies. Thus, quota of reservation should not be more than 50% of the total seats. Giving 68% reservation is a fraud on the Constitution and against the provisions of Article 15, Clause 4. Thirdly, there should not be a class within the class. Thus, division of backward class into two categories, backward classes and more backward classes, will not be permitted. T. Devdasan's case and carry forward rule. Carry forward rule implies that if all the reserved posts were not filled in a year for want of suitable candidates from those classes, then the shortfall was to be carried forward to the next year and added to the reserved quota for that year, and this could be done for the next 2 years. The result of the rule was that in a year, out of 45 vacancies in the cadre of section officers, 29 went to the reserved quota and only 16 posts were left for others. This meant reservation up to 65% in the third year, and while candidates with low marks from the scheduled castes and scheduled tribes were appointed and candidates with higher marks from other classes were not taken. In this case, the Supreme Court struck down the carry forward rule regulating to fill up the vacancies of SCs and STs being violative of Article 16, Clause 4. As a result of the carry forward rule, applicants belonging to scheduled castes or tribes could get more than 50% of the vacancies to be filled in a particular year. Relying upon Balaji's case, the court said that there should not be more than 50% reservation in a single year. In state of Kerala versus N.M. Thomas, the Kerala government framed rules regulating promotions from the cadre of lower division clerks to the hired cadre of upper division clerks, which was made dependent on the passing of a departmental test within 2 years of the introduction of this test. Failure to pass the test within 2 years disentitled the lower division clerk promotion in future. However, by an order issued subsequently under the said rule, the members belonging to scheduled castes or scheduled tribes were granted a longer period and were given 2 extra years to pass the test. In this case, the Supreme Court upheld the decision of the state of Kerala to give 2 additional chances to the candidates belonging to SC and ST to pass the prescribed departmental examination required for promotion as upper division clerk. In Indra Sawhney versus Union of India, which is commonly known as the Mandal Commission case, in this case, implementation of Mandal Commission report wide office memorandum dated 13th August 1990 and 25th September 1991 was challenged, by which 27% reservation was made for the backward classes apart from SCs and STs. A 9-judge constitutional bench of the Supreme Court heard this case, which was decided on 16th November 1992. The findings of the court can be summarized as follows. First, Article 16, Clause 4 is not an exception to Article 16, Clause 1. It is an instance and an illustration of the classification inherent in Clause 1. Second, reservation should not be more than 50%. Reservation contemplated in Clause 4 of Article 16 should not exceed 50%. The rule of 50% should be applied to each year. Thirdly, carry forward rule was upheld. The decision on carry forward rule was overruled, which was the main subject matter of Devdasan's case. However, it was held that reservation should not be more than 50% in a year. Thus, unfilled reserved posts may be carried forward to the next year, but subject to the overall limit of 50% in a year. Fourthly, caste as a basis for reservation. The Supreme Court held that caste can be made a sole basis to determine social backwardness. Caste can be and quite often is a social class in India. If it is backward socially, it would be a backward class for the purpose of Article 16, Clause 4. Fifthly, there is no constitutional bar to classify the backward classes of citizens into backward and more backward classes. Sixthly, creamy layer. The Supreme Court held that creamy layer can and must be excluded. For excluding creamy layer, an economic criteria can be adopted as a measure of social advancement. Sixthly, there should be no reservation in promotion. Article 16, Clause 4 does not permit provision of reservation in the matter of promotion. Reservation in appointments or posts under Article 16, Clause 4 is confined to initial appointment and cannot extend to reservation in the matter of promotion. Seventhly, no economic criteria. A backward class of citizens cannot be identified only and exclusively with reference to economic criteria. Thus, 10% reservation in favor of economically backward class was declared invalid. Inclusion of new clause 4 capital A to Article 16 by 77th Amendment. The rule laid down by the Supreme Court in Indra Sawhney's case regarding no reservation in promotions has been modified by the Constitution 77th Amendment Act 1995, which has added a new clause 4 capital A to Article 16. Clause 4A to Article 16 provides that nothing in this article shall prevent the state from making any provision for reservation in matters of promotion to any class or classes of posts in the services under the state in favor of the scheduled castes and the scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. Catch-up rule and 85th Amendment 2001. The concept of catch-up rule came for the first time in Union of India versus Virpal Singh Chauhan. The same was reiterated in Ajit Singh Januja versus State of Punjab. It was expressed by the Supreme Court that the rule of reservation gave accelerated promotion, but it did not give the accelerated consequential seniority. It was explained by the court that a reasonable balancing of rights of general candidate and roster candidate can be achieved by following the catch-up rule. According to the decisions in above mentioned cases, a reserved category candidate promoted earlier than his senior general category in the feeder grade shall necessarily be junior in the promoted category to such general category. The rule of reservation in promotion factually created a very poignant and objectionable situation in Virpal's case. Out of 33 candidates being considered for promotion to 11 vacancies, all were SC/ST candidates. Even not a single candidate among them belonged to the general category. As a consequence of Article 16, Clause 4, not only the juniors are stealing a march over the seniors, but the march is so rapid that not only compatriots are left far behind, but even the persons who were in the higher categories at the time of entry of scheduled castes or scheduled tribes candidates in the service have also been left behind. Such a configuration could not certainly have been intended by the framers of the Constitution or the framers of the rules of reservation. To negate the effect of the Virpal Singh's case and Ajit Singh Januja's case, Article 16, Clause 4A has been amended by the Constitution 85th Amendment Act 2001. In the amended Clause 4A of Article 16, in place of the words "in matter of promotion to any class," the words "in matter of promotion with consequential seniority to any class" have been substituted. The effect of the Constitution 85th Amendment Act 2001 is that when reserved candidates promoted earlier to general candidates, their seniority in the new cadre would rank from the date of their joining on promotion, and this seniority would not and could not have the effect of getting wiped out after the promotion of the general candidates from their respective dates of promotion, and that of general candidates would remain junior in higher echelons to the reserved candidates. The Constitution 81st Amendment Act 2000 and carry forward rule. In Indra Sawhney versus Union of India, the majority ruled that operation of carry forward rule should not result in breach of 50% rule. This rule does not exist any longer after the enactment of the Constitution 81st Amendment Act 2000, which has added to the following clause 4 capital B to Article 16. This new clause 4 capital B enables the state to carry forward the unfilled reserved vacancies to be filled in any succeeding years so as to remove the backlog, notwithstanding the rule of 50% ceiling. The constitutional validity of 77th Amendment, 81st Amendment and 85th Amendment was challenged in M. Nagaraj case, and the Supreme Court in this case has upheld all these three amendments and held that these amendments do not alter the structure of Articles 14, 15 and 16. The parameters mentioned in Article 16, Clause 4 are retained. Clause 4, capital A, is derived from Clause 4 of Article 16. Clause 4, capital A, is confined to SCs and STs alone. Therefore, the present case does not change the identity of the Constitution. Conclusion. In the end, it could be said that the founding fathers of the Constitution were aware of the ripples of inequality present in the society, decreed the notion of caste and ensured that the constitutional framework contained adequate safeguards that would ensure the upliftment of the socially and educationally backward classes of citizens, thus creating a society of equals. It is the duty of the state to promote positive measures to remove barriers of inequality and enable diverse communities to enjoy the freedoms and share the benefits guaranteed by the Constitution. In the context of education, any measure that promotes the sharing of knowledge, information and ideas and encourages and improves learning among India's vastly diverse classes deserves encouragement, but any such special measure should satisfy the parameters of Article 14 and not in any way abdicate the principle of efficiency. Thank you.